We welcome our witnesses and the members of the public for today's hearing. In the last 6 years, over 2 million Americans have found themselves in a situation where the 40-hour workweek law that applies to virtually everyone else doesn't apply to them, where laws that govern pensions, health care, that apply to just about everyone else does not apply to them, where laws that deal with the right to collectively bargain, the right to organize, the right to grieve, that apply to almost everyone else, does not apply to them. In the last 5 or 6 years, we've had an increase of more than 2 million people who fall into the category in our workforce of independent contractors. Now, in some cases, that status is quite right and quite appropriate. If someone is retained for a limited purpose, usually for a limited time, to do a specific job function for an employer, it's quite necessary and appropriate that that person not be treated as an employee for reasons of flexibility, for reasons of fair compensation, for reasons of the appropriate organization and carrying out of the employer's business. But in cases where someone looks an awful lot like an employee, is told what to do and when he or she can do it, is given no discretion over how to conduct the affairs of the business, whose compensation is fixed and set by the employer. When that person looks an awful lot like an employee, we think the law should treat them as an employee, should provide that person with the protections and the rights that employees have under our federal laws. The question before the committee today was initiated by Chairwoman Woolsey's efforts a few weeks ago. This is a joint hearing of the Workforce Protection Subcommittee and our Help Subcommittee. And Chairwoman Woolsey did a great job with our colleagues in beginning to flesh out the issue as to how prevalent is the problem of misclassification of people. How prevalent is it that someone who truly is an employee is being treated as an independent contractor and therefore divested of the rights that I made reference to earlier? As a result of the good work that Ms. Woolsey did at that hearing, she and I and some of our colleagues wrote a letter to the United States Department of Labor asking that the department outline its efforts in identifying the scope of the problem and outline its efforts to deal with reducing and solving the problem. The purpose of today's hearing is to get answers to those questions that were asked in our letter in May, in our first panel, and then to proceed with the second panel where we look at various perspectives on the scope of the problem, the nature of the problem, and some ideas to solve the problem. Our first witness today, Mr. DeCamp, is the Director of the Wage and Hour Division of the Department of Labor. We're very happy he is with us today, and we look forward to an exchange where we can hear more about the Department's efforts to properly define the scope of this problem and to remediate its effects. I will say this to you in closing my remarks. The image that is often conjured up of an independent contractor is a website designer, someone who designs websites and web pages for a multiplicity of clients and works out of his or her home and is very much on the fly, on the go, an independent entrepreneur with a laptop and a vision and a business card and a chance to make himself or herself a wealthy person. Long may that person be treated as an independent contractor, because they are. But there are people who are mowing lawns and driving trucks and working in garment linen factories, working in all different places around this country, who sure do look like employees to me. And if they have the functional job of an employee, if they're told what to do, when to do it, how much money they're going to make, what the work rules are, what they can and cannot do, if they have that sort of work life as an employee, then I think the law should treat them as an employee. And they should get the benefits of the 40-hour work week and the worker safety laws and the pension and health care laws and the other protections of this country. Legislating is about drawing lines. And where we draw this line and how we deal with remediating problems that fall on the wrong side of the line is the legislative job of the committee. I look forward to a full and vigorous discussion of those issues here today.